Hello, this is Canna Talks with Dr. Ingrid. If you like our content, please click like and subscribe to our channel below. This is part 2 of a video set that looks at the history of cannabis in the US. Briefly, of course. This segment looks at the years from the 1980s until today. There has been a crazy amount of political wheeling and dealing around cannabis in the past 50 years, especially regarding efforts to allow for its medical use. Please join me and let's look at the facts. For a brief recap of part 1 of this video series, cannabis originated in Mongolia and southern Siberia about 12,000 years ago, so approximately in the year 10,000 BC. It then slowly made its way around the world until it landed in the US colonies as Indian hemp, where George Washington was an enthusiastic hemp farmer. It entered the US again via its southern border with Mexico about 150 years later. It was vilified and maligned, used as a weapon against minorities, and was incorrectly lumped together with some other very dangerous drugs such as heroin. Eventually, in the Reagan years, billions of dollars were spent on the so-called war on drugs, and Reagan made the famous, completely unfounded statement that cannabis is, quote, probably the most dangerous drug in the United States today, unquote. Reagan's presidency also marked the start of a long period of unprecedented drug arrests and subsequent incarcerations. In fact, the number of people behind bars for nonviolent drug offenses increased from 50,000 in 1980 to over 400,000 by 1997. But let's get back to the money for a minute. How much does this war on drugs actually cost us? Well, simply stated, since Congress passed the Anti-Drug Abuse Act of 1986 under Reagan, astronomical amounts of money have been spent. Just a reminder, Congress originally allocated $1.7 billion, of which Reagan actually spent $21.5 billion over 2 terms. Funny math, right? As of our time today, $51 billion are spent every year on the ongoing war on drugs and all of its initiatives. Even more staggering, in the 50 years since Nixon first coined the term war on drugs, $1 trillion have been spent on this. That boggles the mind. Let's talk about money a little bit more and look closer at that $51 billion a year tab. How about some rough calculations? In 2018, approximately 4 out of every 10 drug arrests were cannabis related, much more than for any other individual substance. Heroin, cocaine, and their derivatives account only for 25% together. Greater than 92% of the cannabis arrests were for possession only, so nothing violent, and whoever was caught was usually not a neighborhood drug pusher. Now let's plug in some numbers. $51 billion divided by 100% times 40% equals $20.4 billion. $20.4 billion every year. That is crazy. This also begs the question of how many billions of dollars more we want to throw at a problem before we go back to the drawing board and look at what we are actually doing. But now, let's jump back to the 1980s and see what happened at the end of the Reagan era. In 1988, the DEA's own administrative law judge, Francis Young, challenged the DEA to reschedule cannabis. He did not even request unscheduling per se, but wanted cannabis moved to Schedule II, which would allow for medical use. This was in response to a petition filed in 1972 by NORML, the National Organization for the Reform of Marijuana Laws, a political activist group. This means that the original petition, which Judge Young ruled on, was filed 2 years prior to Nixon's resignation, and Judge Young's ruling finally happened 16 years later. What? I'll explain later. Judge Young conducted diligent research over approximately 2 years and came to the conclusion that, quote, marijuana in its natural form is one of the safest, therapeutically active substances known to man. By any measure of rational analysis, marijuana can be safely used within a supervised routine of medical care. DEA Administrator John Lawn later rejected this ruling, and cannabis remained a Schedule I drug. A few things about Mr. Lawn. Prior to his appointment, he was an FBI agent. He was not a legally trained professional like Judge Young, nor was he a physician. He was a law enforcement man through and through. And while he was exercising his power as it had been given to him, he did overstep his actual qualifications. For further edification, his job immediately after his retirement was with the New York Yankees. But there is actually much more to this story. The original petition by NORML was filed in 1972, during the Nixon years, right after cannabis landed on Schedule I. Federal authorities initially refused to accept it until they were mandated by the U.S. Court of Appeals in 1974. Despite this, the DEA still refused to process the petition and had to be ordered again by the court in 1982. In 1986, 4 years later, the DEA finally allowed public hearings on the issue before Judge Young. That's when Judge Young's 2 years of research and review began. In 1988, Judge Young finally rendered his decision, after careful and diligent consideration and many, many hearings. That is 16 years after the petition was originally filed. And as we know, DEA Administrator John Lawn overruled more qualified people and rejected it. NORML appealed Lawn's rejection, but in 1994, the Court of Appeals allowed it to stand. God knows on what grounds, because it certainly does not seem just. So it took 22 years to get from the petition to a final ruling. To illustrate this in grossly understandable terms, if you had a baby in 1972, you would be celebrating your baby's college graduation in 1994. That is perverse political maneuvering at its finest. So what happened then? Let's go to California, the Golden State. Activism does not stop, of course, especially when there is a dire need that is not being met. Judge Young stated, quote, "It would be unreasonable, arbitrary, and capricious for the DEA to continue to stand between those sufferers and the benefits of this substance in light of the evidence in this record," unquote. Well, unfortunately, this is exactly what happened. Enter Proposition 215, the Compassionate Use Act, or simply Prop 215. This was a voter initiative started by a group of political activists, including Dennis Peron, who went directly to California's voters when they could not get the federal government to respond. Dennis Peron was the main driving force of this, although other activists were involved. His partner had died of AIDS, which ravaged the San Francisco area in the 1990s. It was at his partner's eulogy, actually, that Dennis swore to fight to legalize medical cannabis. And it worked. Prop 215, the Compassionate Use Act, passed in November 1996, allowing for the legal distribution of medical cannabis products. This made California the first state to have had some success in fighting the capricious ruling of the DEA. But this was, of course, not the end of the troubles for California. Far from it. Almost immediately, the federal government buckled down and vowed to uphold federal law in California. Translate, President Clinton and Attorney General Janet Reno were the driving force in this. I am sure most everyone remembers that President Clinton, when he was studying abroad in London, experimented with, quote, marijuana a time or two but didn't like it and never tried it again, unquote. Famously, he did not inhale. While some people had doubts about his truthfulness regarding this, it must be said that at least his mom believed him. She said in an interview that Bill always had asthma and definitely would have had difficulty inhaling. Interestingly, though, one of his contemporaries, who was in England at the same time, talked about Clinton's fondness for cookies and other edibles. Be that as it may, as for Janet Reno, she died in 2016 after suffering from Parkinson's disease for 11 years. A neurodegenerative disease like that responds extremely well to cannabis. It is not known whether Janet in her later years, and to alleviate her own suffering, might have finally embraced the benefits of cannabis. It would have made a world of difference to her in any case. So what did this federal crackdown launched by Clinton and Reno actually look like? Something called Pre-emption happened, where the federal government imposes its authority and overrules the laws of a state. Almost immediately, cannabis dispensaries who operated legally and with the permission of the local government were raided by the DEA. The DEA showed up with SWAT teams and descended on clinics that distributed needed cannabis medications for free, and literally confiscated all products, leaving patients empty-handed. SWAT teams also overtook legally operating cannabis farms, arrested their owners, and destroyed their crop. These raids continued through the presidency of George W. Bush, who endorsed them enthusiastically. Bush, while admitting to plenty of bad habits, always avoided a direct answer regarding cannabis, but eventually was caught saying, quote, "I wouldn't answer the marijuana question, you know why? Because I don't want some little kid doing what I tried," unquote. Really? At the current time, the DEA states that any raids being conducted are related to cartel-connected illegal growing operations only. So what else has the DEA been up to? More petitions have been filed and denied, even when legalization of medical cannabis had been won in several states, and even after the Institute of Medicine stated in 1999 that cannabis does have medical uses, along with a relative low abuse potential. In 2016, Scientific American published an article called "The Science Behind the DEA's Long War on Marijuana." The article stated, quote, "Experts say listing cannabis among the world's deadliest drugs ignores decades of scientific and medical data, but attempts to delist it have met with decades of bureaucratic inertia and political distortion." That is certainly a mouthful, and it seems to hit the nail right on the head. In July 2011, during the Obama administration, the DEA rejected yet another rescheduling petition, and this rejection was affirmed by a 3-judge panel for the U.S. Court of Appeals, stating there are, quote, "insufficient clinical trials," unquote, to warrant a judicial review. Good grief. But wait, the thing about the insufficient clinical trials, this actually represents a classic Catch-22 scenario. The definition of Catch-22 is, quote, "a problematic situation for which the only solution is denied by a circumstance inherent in the problem," unquote. Bingo! The DEA and National Institute on Drug Abuse have actually imposed a federal blockade on exactly the research needed. And the only legal source of cannabis to study would have to come from the National Institute on Drug Abuse, which has a congressional mandate to only study its harms. This has been an untenable situation for a very long time. Researchers literally risked arrest and jail time for conducting the studies the Court of Appeals said were lacking and which it wanted to see. No one wants to end their professional career like that. Very recently, the restrictions have been loosened a little bit, but we are far from where we need to be in terms of being able to conduct proper studies. There is actually lots of research from other countries, including Canada, Israel, and even the Netherlands, which decriminalized cannabis in 1976. So, where are we today, in the summer of 2022? Medical cannabis has been legalized in 37 states. Some states have passed modified laws which restrict the use of THC content, not always in helpful or easy to understand ways. Some states have legalized even recreational cannabis, and some other states remain stubbornly opposed. Overall, though, the situation is dynamic, with several states, even very conservative ones, at least working towards the legalization of medical cannabis. The federal attitude towards cannabis remains a disappointment, however. In the House and the Senate, bickering and the unwillingness to cooperate seem to supersede the desire to serve the people. And let's face it, some elected officials don't seem all that bright, and may not even truly understand the history of cannabis. But efforts to get cannabis off Schedule I are underway. On April 1st, 2022, the MORE Act passed in the House. This stands for Marijuana, Opportunity, Reinvestment, and Expungement. Unfortunately, a previous version of this act was allowed to die on the Senate floor in 2020. At the same time, the Senate Majority Leader, together with the chairman of the Financial Committee, have just introduced a federal bill designed to deschedule cannabis and allow state decisions to stand without fear of federal interference. This bill is called the Cannabis Administration and Opportunity Act. Both bills seek to right past wrongs and to de-vilify cannabis on the federal level. Since the members of Congress, by and large, cannot agree with each other on anything, it is not likely that any of these bills will actually pass this year. But it is definitely a step in the right direction, which would have been, quote, fantastical in the not-too-distant past, unquote, according to the New York Times. This concludes part 2 of a brief history of cannabis in the US from the 1980s to the present. Obviously, there are many more details I was unable to touch on, but lots of information is available on the internet. So educate yourself and learn about this very important issue, which is in the news and debated all around us. The description below also contains a few interesting links which support this video. As before, please post questions or comments below. And don't forget to click like and subscribe to our channel. See you soon for more topics on Canna Talks with Dr. Ingrid. Ciao!